Participants, kindly check your participant POC group. There has been a change in the venues of the paper presentation. So please check the participant POC groups and join your respective WhatsApp groups sent in the group, okay?
Hello. Good afternoon, ladies and gentlemen. Our next session is a panel discussion on the non-traditional trademarks in media and entertainment, brought to us by our wonderful sponsors, Advocate Sairam Sanath and Advocate Paul.
It is my honor to introduce the first speaker for this session, Advocate V.C. Matthews, partner at Fox Mandal in New Delhi. Advocate Matthews is a graduate of Symbiosis Law School, Pune, and further honed his expertise with an LLM in intellectual property law from Queen Mary University of London. With a rich experience spanning 17 years in intellectual property law, Advocate Matthews has become a go-to expert in handling various aspects of IP, including trademarks, copyrights, and designs. His expertise spans the entire spectrum of IP services, from conducting clearance searches to managing registrations and enforcement strategies. Sharing his knowledge and passion for IP law, Sir is a frequent speaker at events organized by CIPAM and FICCI. He has also served as an adjunct professor of IP law at SLS Noida. On the international stage, Sir is an active member of the prestigious International Trademark Association and is a regular presence at their conferences. Ladies and gentlemen, please join me in welcoming to stage a true pioneer in the world of intellectual property law, Advocate V.C. Matthews.
It is my pleasure to introduce our next distinguished speaker, Dr. Kavita Chalakal, who is currently serving as an assistant professor at the Inter-University Center for IPR Studies at Kochi University of Science and Technology in Kerala. Dr. Chalakal's impressive academic journey includes a PhD in International Environmental Law from Jawaharlal Nehru University, an MPhil in Public International Law from the same institution, an LLM in Intellectual Property and Environmental Law from Cochin University, and a BA LLB from Kerala University. With over a decade of experience in academics and the non-governmental sector, both nationally and internationally, Dr. Chalakal brings a wealth of knowledge to her field. Her career spans various roles, including her time as Assistant Director Research and Assistant Professor at Lloyd Law College for nearly a decade in Delhi NCR. Dr. Chalakal's expertise has been recognized globally. She is a member of two prestigious commissions within the International Union for Conservation of Nature, the World Commission on Protected Areas and the World Commission on Environmental Law. Her academic excellence was further acknowledged when she was awarded the Fox Foundation Fellowship at Yale University for 2009 to 2010. More recently, she was named a research fellow at the China South Asia Legal Research Center of the China Law Society in 2018. Ladies and gentlemen, please join me in welcoming ma'am to the stage.
Our discussion will be moderated by Dr.
Our moderator would be sitting in the middle.
Our discussion will be moderated by Dr. Nandita Narayan, Assistant Professor of Law at the National University of Advanced Legal Studies, Kochi. An alumnus of Nuals, she holds a PhD in philosophy focusing on artistic freedom. Ma'am specializes in constitutional law, criminal law, and human rights with particular emphasis on sexual minorities, gender equality, and freedom of expression. Over to you, ma'am.
Hello. Good afternoon, everyone. We have with us two brilliant panelists, one an academician and the other a person practicing in this area. This is a very interesting area of that has come up for discussion. non-traditional trademarks in media and entertainment law. So this basically encompasses anything that is non-visual to enhance the whole experience or idea of the piece of work. It could be color branding, it could be sound branding. To give a simple example, Netflix, the sound that comes to before we see the show is a perfect example. So to know more about this, we will have them talk in this area. Each speaker will be given about 15 minutes, after which, after both of them speak, we'll have a 15-minute Q&A. So I'll first invite Dr. Kavita. She'll probably take you through the nuances and literature in this area. Over to you, ma'am.
Thank you, Nandita. And I know this post-lunch session is slightly risky for both of us because you are all full with a very tasty lunch. And the natural tendency after Sadhya lunch is to sleep. So you can expect the Chinese classroom model, stand up, wave your hands and swing your legs, etc. to wake all of you from your slight distraction that may happen. Hopefully it won't. So today in this panel, we are going to discuss the elements of non-conventional trademarks and in the context of this conference, how it affects the media. Would I have a... Yes. So I expect all of us to be familiar with the basics of trademark. And trademark traditionally had the role of a source identifier. So it was basically a communicative thing. And it's only in the 19th century you would see trademark moving to a concept of property. And the legislations which came in the 19th century, late 19th century, properly commercialized it and identified it as something which has values. And when we discuss about trademark and media, in the conventional sense, the conventional, do you have the pointer? Pointer undo? You have slightly. So just move to the next slide.
Yeah, no, so I'm giving cues.
Yes, okay. So traditionally, the signs, logos, etc. was trademarked. There was no confusion because law says as long as you can prove it as a graphically expressed one and as long as it is distinctive, you get registered in trademark law. But the change in technology and the changing platforms have created new venues for trademark law to venture into, and it is related to media. So basically, in social media, we have been seeing these hashtags. We liberally use the hashtags to increase the view, but now these hashtags are getting trademarked, especially with regard to film actors and popular figures. They want to attach the hashtag to their personality. And then we have the, film song, which was being registered in India for the first time. That was by this Kolaveri. And then we have film titles such as Sholay and the issue between Ram Gopal Verma and Sacha Sippia with regard to the re-release of, the Sholay one, Ram Gopal Verma ke Sholay. So those things which have always been happening for the last 30, 40 years. And we have now the celebrity moves which is being trademarked. For example, Jordan's dump smash or slam dunk and Usain Bolt's pose, etc. And for the law students here, this is just a glimpse to the regulatory framework which governs trademark. And with regard to non-conventional mark, please note that it is a Singapore Law Treaty and its 2011 regulation which talks about non-conventional trademark. But basically, all these treaties have said what to protect and what are the standards to be set for that under the domestic jurisdiction itself. They have not given any requirement other than graphical representation and distinctiveness. So when we look into the definition of trademark in Indian Act, you can see that our definition is very wide. It's not a inclusive definition which doesn't allow any other character or any other type of mark to be included into its definition. So that nature itself gives that there is a scope for protection of non-conventional mark, even though it is not expressly stated in our statute. And the main concern with regard to non-conventional mark is like trying to fit in something like, it's almost like teaching a fish to climb the tree. because the registerability of the traditional trademarks are the same standards which we apply for the non-conventional mark also. So graphical representation and distinctiveness. So as long as these two criteria are fulfilled and you select the class according to the NIS classification, your trademark can be registered. So the slide behind me shows the general categorization of non-conventional trademark. But we need to remember, whatever is the category of the mark, they always have to prove graphical representation and distinctiveness. And so I'm just going through the basic ones. You have the olfactory marks. So it's very difficult to describe a smell, because when you explain a smell, for example, someone may have a high sensitivity towards smells and might be able to distinguish between, for example, if you wear a perfume, and an expert could easily tell what are the layers of the perfume. But a normal person may not be knowing that. We will just have a jasmine perfume. But they might have an undernote of lilac, another note of lavender, etc. So those issues would be an expert's thing. So you can see that despite this limitation, they have registered a couple of things like tennis balls with freshly mown grass fragrance. I really don't know why tires would smell like a rose, but they have registered it. Then darts with a strong smell of bitter beer. Maybe the pub and bar might have prompted that. And the other category of olfactory mark is color marks. So recently I knew that the parachute oil, which we all see, that blue is now color marked. And then we have Victorinox handle, which is marked. But surprisingly, one of the most popular color, the Pantone purple for Cadbury's, took almost 30 years. And it was only in last year that the UK High Court recognized a part of that color as an exclusive packaging. All other applications have been, Cadbury's have been trying it from, I think, 1994 in its renewal trademark application, and Nestle has been objecting it in all forums wherever they apply. But recently they got a minor success. But the problem is, whenever there is a color, it must be a sign. That sign must be capable of graphical representation, and the sign must be capable of distinguishing the goods. So these conventional standards applied to non-conventional marks creates a lot of issues with regard to its protection. So when it comes to media, we have mainly 4 marks which are important. That is sound mark, shape mark, motion mark, and fluid marks. So when we look into sound marks, I'm not going to each of these cases. I just want you to understand. All of you remember the Tarzan's yell, if you have seen the Tarzan movie. So initially the application was rejected because no one could adequately express the yell. Then they sound engineered it and they prepared a graphical representation of the yell. So when I take this in my classroom, I usually play the yell in different stages so that you can understand how, like, you know, it's what we said, it's very difficult to express that yell. And then the lion roar by MGM, the Tom and Jerry beginning. So those things got registered, not in the initial ones, but later when they were rejected and they tried to overcome the difficulty in the registration. And similarly, in another case, like shield mark was juice kissed, or most of you might know this case. It was about the Furrelis, a Beethoven music composition. We are all familiar with it, the Ajanta clock tune, that one. So this was on music stave. See, I make all these things so that you don't sleep. You are not supposed to make, you should laugh, but you should understand my artistic limitations. So this was on music stave for one party, and the other party came up with an onomatopoeia, that is, it sounds as the word says. So in that one, it's like ma'am actually said earlier, the defendant used the same note in the sound of a cockcrow, kokoroko, that sound. He made Furrelis in that, in a computer-generated one, but it was rejected because they were not able to express it correctly. And the court also held that when it comes to an onomatopoeia, that is a word which sounds exactly it is spelled. For example, boom. But if it is like in India, we have different regions pronouncing letters in different way. So in Orissa and West Bengal, you would see that they don't spell F, they say P. So instead of 5, they say 5. So in those instances, you can't expect the word to sound as it is spelled. So on these instances, no, they did not take Indian example, but I just said that for your knowledge. So in these instances, it was not given a protection, or the infringement action did not work there. And when it comes to sound marks in India, we are very accustomed to it. So you have the Yahoo Odal, then Hero Vroom. When you see the advertisement in Hero, they have a special Vroom. And then Nokia, the one of the most common opening tune for mobiles. Then we have this iconic dialogues, which is like known. So in Malayalam, if many of you are Malayalis, you know that Irubadam Nuttandu, that particular that one, CBI one, and the Irubadam Nuttandu one, all these are in the process of getting. See, I just become very involved in teaching, okay. And I'm not going to say that EO, that one, the Pitbull's one, but this is how they represent the sound mark in India. You have to give a graphical representation. And when you hear that room, you should remember that it is from Hero. So that distinctiveness also needs to be proved. So sound mark is one non-conventional mark in which media has a lot of scope to work on. Then we have motion marks. So motion marks is like, something which moves. And most of the production houses have a moving image as their as their trademark, which comes to a standstill. So it will roll around, run around, jump around. In some you can see them going to the space, landing on the moon. The Dream Flower, I think they come like that. So all these are part of a single trademark. So basically the 20th Century Fox logo, it is a multimedia one. It doesn't have sound, but in this presentation, usually it is accompanied by a sound. Similarly, the Netflix, tudum, I don't know how that comes out, but then, and they have even trademarked Amazon's that light movement, Amazon Echo's light movement. They have trademarked it in 5 different shades, how it turns around. And that is one area that non-conventional mark is going to make a huge difference for media. Then we have shape marks. Shape marks is essentially, rather than 2-dimensional, it is 3-dimensional. And it existed previously from 1940 itself. I think Japan had given a 3-dimensional protection for Coca-Cola bottle. So we have been giving protection to shapes. So one of the funniest thing which I found in today's when I was preparing for the classes, Akshardham temple is now shape marked. Those who have seen Akshardham, so they have taken a photo, a prototype of a shape, and they have trademarked it as a shape mark. So no one can create it. And then we have the next category, that is fluid marks. Fluid marks are basically different versions. Best example is Google. When you open the Google tab, the Google doesn't remain the same. It moves, it changes. If it is Independence Day, or if it's your birthday, it treats you with balloons and stars and other things. So that is a fluid mark. And similar to that is Amul has also marked the face of the Amul girl, because she comes in different attires, different faces, and different positions. And Starbucks have also done that with mermaid face with a mask. They have also marked it as a fluid mark. So these are the categories of non-conventional mark in which media has a higher scope of work, or where it is more applicable to the media. Another issue which comes with regard to trademark and media is the issue regarding product placement. Those who are watching these YouTube videos or YouTube series, one of the most recent example is Karika. Because sometimes we feel very odd because the product placement is too much for us to connect to the scene. And there are certain shots also. For example, I think Chural, it began as a very, very comic one, and now they have come up with these apps which are being promoted. Or when you see any movies, when you see a particular product in a very significant place, you can understand that it is a product placement. Now, product placement is not as such an issue. Product placement is only an issue when you place it without their permission. So usually these people are also happy. For example, in Chup Chup Ke, when he washes with that tide, the hilarious scene of washing clothes immediately increased tide sale. And children who watched Krish wanted to drink Bonvita. So these things are like, product placement is also sort of advertisement, but it also involves use of trademark. So what would happen is that, for example, in one movie, Ranbir Kapoor makes some comment about Roo Afza. And Roo Afza filed a complaint against Karan Johar saying that it has affected its goodwill. And the court said that you cannot have a television release, but theatre release was permitted by removing this particular dialogue from it. So when you have these product placements, or when you describe a particular product in the media, whether it is a movie or in any print media, these issues would come. Because it is not just a, defamation they may go with, they may also go with a trademark infringement proceeding. Another emerging area for the media to deal with, and law is trying to adapt to it, is trademark in metaverse. So you would see many cases where the traditional, conventional marks which have been registered in the trademark office of different countries have been violated in the metaverse. So if a metaverse character is carrying a Gucci bag without Gucci's permission, it's a trademark infringement because Gucci's trademark is being displayed there. So media has all these issues, and it's very difficult. I don't know what happened to the next slide. Is it okay? Yeah. So when you look into the metaverse, it has a lot of challenges, but the main problem is trademark, even though has many international treaties to cover it, is a territorial right. And metaverse is something beyond the territory. So applying a particular jurisdiction's law to a trademark in metaverse would be difficult. But you can see a lot of companies are already, already working on those, and they have already registered their trademarks in metaverse also. For example, Facebook has done that, Reliance has done that. Many companies have been doing all those registrations to cover the placement of the trademark even in metaverse. And the way forward would be permitting multi-class, because if you remember your trademark classes, you know that there are 45 classes, so we'll be elaborating on that. So in those, you can see that you may register not in every class. So in metaverse, it is becoming a necessity that you may have to register in majority of the classes which would be applicable for you. And you need to be concerned about the the law has to be concerned about extension of trademark law into digital space. And there, the territorial sovereignty or the jurisdiction issues will come up. And to conclude, I think I reached in time, yes. So to conclude, we can understand that applying, or I read it in a paper, conventionalizing non-conventional trademark. So you are trying to fit in a new category to a traditional category of protection, even though we understand the rationale behind it, because graphical representation allows the registry to identify what is being protected, because we don't, support monopoly. So these registration requirements or the standards or the subject matter requirements are essentially the limitations on the protection of that particular category, or the ensuring that the public domain remain vibrant. So even though we understand the rationale, we need to question whether the same standards could be applied in its extent. I don't know how I am going to explain a particular fragrance as it appears to me or as it appears to ma'am. We may have different senses, and I always, I always make my children imagine walking around in supermarket aisles and smelling things to identify whether it is from this company or that company. So you smell, okay, this fragrance is not good. Because smell marks or olfactory marks also says that it should not be descriptive of the product. So the perfume cannot have a perfume smell. A tire can have a rose smell. So imagine you going to a tire wholesale shop and smelling every tire for its fragrance. So these traditional conventional notions of standards and registrability may create problem for the non-conventional marks also. And another problem is functionality, because sometimes non-conventional mark, for example, shape marks, may have a role in its functionality also. So to exclude the functionality is the law, is the rule which we follow. So to what extent we can do that in non-conventional markers, another question. So as a conclusion, what I would like to say is that Indian trademark law is open to the registrations in non-conventional mark, but it still has a very long way to travel if it has to expressly incorporate that into our Trademark Act. Because most of the international laws gives it as a flexibility or as a, what we say, exclusion to the states to decide what to protect and how to protect. They only say the standards and the term. So thank you for listening.
Thank you, ma'am, for taking us into the different types of non-traditional trademarks in media and entertainment, especially starting from the peculiar nature of olfactory trademarks to sound marks and motion marks, and also product placements and trademarks in metaverse. I think it was a very beautiful session, and time was perfectly managed in under 15 minutes. I will now probably ask Matthew to take on the floor.
Thank you, Nandita. Okay, I'm going to shift this up slightly. So,
would you like us to step down?
No. You can sit there. I'll step down. First of all, thank you so much, Nuals, for having me over. It's a pleasure coming back. There's a reason why I said coming back, because I was supposed to come here initially when I was getting into law school. That did not happen. I don't think my father liked me very much. He sent me to Pune. You don't send a Malayali to Pune who doesn't know Hindi. It doesn't work out very well. But yes, on the trip today, I've managed to meet some old friends again. So it's homecoming, you can say, in one way. When I said I'll shift it up, because I think I'll shift it up because let's get some interaction from the audience up and running. People at the back, the guys in the gallery, don't worry, I like you very much. I used to sit there. If I attended this lecture, which normally would not happen because I was out playing football, okay, or other extracurricular activities, not mood courts, anything else. And guys in the front, don't worry, I know you're very attentive. We'll keep the questions rolling. Now, ma'am, you touched upon something very interesting when you said graphical representation. So what we're going to do is basically through me, we're going to understand what the law says, okay? We're going to understand what is there in that little thing called the Trademarks Act. We're going to understand what a trademark is as well. I'll start with that. And then we'll go on to maybe try and understand how each of those things that ma'am had mentioned can or cannot be done. Okay, and when she calls it out, you can also try to see whether you can analyze from the initial portion of what I'm trying to say, whether it can or cannot be done. Okay, just think about it. So, how many of you have done your IP classes? Or, okay, a few hands going up, a couple of hands down. So, for the sake of everybody, to bring us all on the same page, intellectual property is very simple. It's nothing but a story of every single founder, right? Every single image, logo, name, whatever you like, it's a story. And what I do is I just protect those stories for those founders of those companies. Nothing more, nothing less. How I go about it is obviously through the various acts which are there, and the act that we are dealing with today is the Trademarks Act. Okay. Now, within that Trademarks Act, and if you look at your phones, the best way to examine a trademark is just look at your phones, those lovely shiny little devices which are sitting with you. Now, at the back of each of those phones or on the front of the phones, you will see a logo on it. Okay, can you just take a look at your phones? I know you like looking at your phones, but not the WhatsApp, just the phones. Okay, otherwise I'll be thrown out of here very fast. Okay, so yeah, so you can see various logos. That could be a Samsung, that could be a Xiaomi, that could be an Apple. Okay. And so on and so forth. Now, question to you is, if I was to say that I would buy each of your phone, what phone would you pick? Anyone? Money is no cost, no problem. Anyone? Samsung, okay. Anyone else? I'll come back. Anyone else from that side? Nokia, okay, wonderful. I used to have those. Yeah. Okay. So let's try to understand why. Why Samsung? It's got better features. Okay. It's long lasting. Great. Okay. Let me change that question to you. Is the same reason for Nokia? You feel at peace. Why? He feels calm when he listens to Nokia. Okay, the music of Nokia. Okay, not a bad reason at all. So there's something which is similar here. Okay, okay. Let's tweak that question slightly. Okay, you want to buy a Samsung, you want to buy a Nokia. Features are what you looked at, long lasting, and so on and so forth. Let's say there is another phone like that, exactly similar. Okay, maybe lesser price but no logo on it. Would you still purchase it, or would you still go for the Samsung? Samsung. Why? Your previous experience. So the reason why she went for the Samsung is the simple understanding that as human beings, we like to purchase something that brings us a little amount of safety. That calm that we get that, yes, I'm purchasing a product which is going to last for a very long period of time, which has got a quality attached to it, a reputation attached to it, and a lot of goodwill which comes along with that. That is why we are purchasing that product. Now, that is basically nothing but a trademark. That's what the trademark is supposed to do. It's supposed to denote origin, where it is coming from, and it is supposed to give us this feeling of calmness or a reputation of goodwill and the reason to purchase more. And that is the same reason why you would sell a kidney to buy a Apple, which is 1.5, I think, right now, right? If I'm not mistaken. So yeah, it's the exact same reason why people line up outside an Apple store the night before to purchase an Apple iPhone. Okay, so the brand, the reputation that it garners. Now, understanding that, so that's a trademark. Everybody got it? Any doubts? No? Okay, great. So that's a trademark. Now, you had words, logos, slogans, images, all that coming as trademarks. We have understood that. It's pretty simple to understand, right? But what happened was, with time and with the advance of technology, which helped us not only to bunk class and not give attendance. Earlier it used to be much easier, now it is not so. Earlier we just had to sign those attendance sheets. Now you have those biometric things which don't exactly help a lot. But similarly, trademarks too underwent a lot of change. Okay, so now with change, what happened was you have a new set of things which could be represented as trademarks. And that's what Kavita ma'am had touched upon when she elaborated a whole host of marks which were not originally regarded as trademarks within the definition of what a trademark is under the Act. Okay, and these whole gamut of marks which came with the advent of technology came to be understood as non-traditional trademarks, or marks which are not traditional in nature. Simple. That terminology is just one which is created to encompass this wide array of marks which were not traditional in nature. And again, the whole list of that was told slightly earlier. We'll go into that as well. Now, the biggest thing in India under the Trademarks Act was that any trademark, for anything to be considered, like if you want a logo on your badges to be regarded as a trademark, it has to be graphically represented. That is the underlying condition for something to be classified as a trademark. It has to be graphically represented. Thank you. It has to be graphically represented, right? So to be graphically represented, you need to be able to draw it on a piece of paper. Yes, the ladies in the front. You need to draw it on a piece of paper. Could sound have been drawn on a piece of paper? Yes. Okay. Okay. Hold on. How many of you say yes? How many of you say no? How many of you say yes, it can be? How many of you say no? Okay. Let's take somebody with the no from the back. The gentleman in the back who raised his hands. Okay. Who said no there? Someone said no there. Can someone tell me why you do not believe it can be represented graphically? Okay. Anyone? It's okay. Why can't sound be represented graphically according to people who believe it's no? Why can't it be represented graphically? Anyone? How many of you sing here? Yeah. Yeah, sure. Go for it.
I think that it. Hello. I I don't think that sound can be represented graphically because while you can consider sheet music to be a representation of the elements of the sound itself, like the notes, the pitch, whatever it is, the sound itself is known as sound because it's heard. So that conversion will not make, or any sort of sheet music or representation of the elements of sound cannot make the sound itself. So I don't think sound can be graphically represented.
Right. Can we have a counter to that, please? You were the one who was saying. Yes, sorry. Yeah. You can use this.
I think the representation of music or sound as sheet music, it allows replication of that music as well. Of course, it cannot be always be identical because of personalities or different artistic styles of persons, but it can be replicated because of sheet music or notes.
Okay. So this kind of confusion was what stopped sound from being considered as a trademark for many years. Okay. 50% saying yes, another 50% saying no, some people sitting on the wall saying, okay, let's see which way this goes, and then we'll accordingly shift our vote that way as well. Okay. Eventually, what happened with time was that certain sounds became so obvious that you, the consumer, could regard it, you can hear it and immediately say, oh yes, that's belonging to a Nokia, or that belongs to an MGM, and so on and so forth. These sounds became synonymous with the product itself or the brand itself. So Nokia had a wonderful ringtone, okay, and funny story, at one point of time, everybody in college had Nokia phones. I think Nandita will remember this flood this time. And not that old. I never said you were. Okay, but so during those times, 5 of us will be sitting in a college canteen and the phone will start ringing and everybody looks at the phones because everybody has Nokia phones and everybody has the same ringtone. Again, the phones used to light up, so that's the only way we could know whose phone was actually ringing. Okay, so this is just a way to show you that Nokia's, that sound was so popular. No, I'm not going to sing it. For those who are waiting for me to sing it out, no, that's not going to happen. So this is how sound came to be regarded or synonymous to the brand or the product itself. So it kind of denoted origin. Remember when we started talk about a spoon with a brand on top of it and how we relate to that brand. Exactly similar sound started being relatable by the consumer, you and me. Okay, so what then had to happen was the condition of graphical representation needed to be substantiated or validated. To do that, we went into the musical notations. Okay, the sheet music as I called it. It's basically the musical notations. With the musical notations, one was able to graphically represent sound, thus meeting the condition required under the Trademarks Act 1999, which governs the Indian trademark law. Once one was able to satisfy that, one then could regard sound as a trademark. I'll go into, from the trademark office's end and what we as practitioners have to do, I'll go into that when ma'am throws out these different types of non-traditional trademarks at me, and I'll try to elaborate from the trademarks perspective how it actually works and how we actually get it done as well. Okay, because that's a lot of understanding, because you need to know how to get it done. Understanding that it can be done is one thing, understanding how it is done is another thing. Okay, so let's understand that as well. So this is how sound was regarded as a trademark. Okay, there was another one raised, perfume. Can perfume now be graphically represented? Yes or no? How many people say yes? Raise your hands. None. None. Okay, just one. Okay, yes.
Some extent, because you can use the notes and represent the notes of each perfume. So how perfumers create perfume is there's a base, middle and top note, and they do it with the notes specifically. So obviously you cannot entirely represent the final product, but the ingredients and the notes can be represented graphically, probably.
Okay, great argument and wonderful answer. This was basically what was taken up in the UK or the European Union, if I'm not mistaken. Unfortunately, The problem was basically one wherein in the trademark procedure for most countries, there is an option of an opposition. That you can oppose, any of you can oppose a trademark which you believe is similar to your client or deceptively similar or identical, okay? Now the problem with the smell marks, olfactory marks, was basically this. You couldn't reproduce that for the general public. Secondly, weather. Weather plays a huge part in perfumes and scents. Okay, it can change depending on weather. It can change depending on the liquid used as well. Okay, or even the percentage of the chemical which is added, that also changes. So these were problems which are practical problems, and we have another practical problem, which is the trademark office nowhere in the world has the ability to be able to store this safely, okay, without it getting damaged. So practical problems dictated that smell still isn't regarded as a trademark. There was a very funny one which was cited by Kavita ma'am regarding a tennis ball which smelled like freshly cut grass. Yes, that is an actual case. There was a genius who wanted to do that and who filed for that. He was refused. Okay, but this is an actual case. That is one type of it. There is another type of mark which was not touched upon. That's a shape mark. So a shape can be regarded as a trademark as well. If I take a Coke bottle and I don't write the word Coke on it, how many of you can relate to it? Can you have a show of hands, please? Quite a few of you can see a Coke bottle without Coke written on it and relate to it, right? Excellent. How many of you can relate to an old monk bottle? Okay, there's somebody in the front. The alumni are discarded from this conversation. That's a conversation they don't want to have right now. Okay, yes, with the giggles we can know how many people can relate to an old monk bottle. But yes, exactly similar. A shape can be regarded as a trademark, and it was part of the non-traditional trademark regime. It came out of it because more and more shape marks started to be filed for. Okay, it's something which is not so easy to do, but something which is still done. There was a touch upon color marks. I'll elaborate on that as well very shortly. Now the objection, okay? We've understood what a non-traditional trademark is, we've understood what a trademark is. Now let's understand what the objection is as per the law, and objection which can be raised is. Now in the Trademarks Act, there are two sections under which objections can be raised, and objections from the Trademark Office are always raised at the examination stage. So you file a trademark, you go to the examination stage, and that's where the objections are being raised. The biggest objection that is raised for any non-traditional trademark, and this is a given, is one under section 9. You can forget the section number. It is basically this. They say that the mark is not registrable because it is not distinctive enough. So the question as to distinctiveness is raised on a non-traditional trademark as a given. So you file a non-traditional trademark, they will raise a section 9 objection. It's a given. So you have to prepare yourself and you have to prepare the client even at the time of filing for such kind of a issue. Okay. When we did a signature trademark, a signature for a client recently, we knew we were going to face that objection. So what we did was we loaded the deck at the time of filing, saying that the mark was already in use for 30 years, showed the evidence of 30 years, and loaded up the evidence with a 100-page evidence at the filing stage. You would be very surprised to know that the Trademark Office did not raise an objection. They allowed it to go to publication in the Trademarks Journal directly. So we were prepared. We understood that this question would arise. But we were lucky enough that their objection was not raised. They read the evidence and they understood that this is not a matter they would like to contend with us on. So they allowed it to move forward to publication and subsequent registration. So this is how you strategize when you have a non-traditional trademark in play which needs to be registered. So you will have a lot more of this now. And why do you have a lot more of it? It is simply because media is something that is now encompassing every form of our lives. So if you look at your phones, you have reels coming in through Instagram, you have advertisements. Advertising companies are looking at OTT platforms and other platforms for advertisements. So you're going to have increasingly increased number of non-traditional trademarks or motion marks and such coming up in your faces in the future. And you're going to have clients coming and say, listen, we want to kind of get this trademark because we have got this huge amount of advertising spend and if consumers relate to it and so on and so forth. So this is something that is going to happen for all of you. Okay, and saying that it's going to happen is all well and good. Now let's try to understand how we would actually get across this. So ma'am, Kavita ma'am, can I take your help here please? Could you please call out each of those marks? Okay, I think you can only come clear. And I'll try to explain from a trademarks practitioner how we would tackle that and what the problems that can be foreseen are. Okay, you with me? Good? Okay, ma'am.
Matthew, just a reminder, can we keep that under like 10 minutes?
Yeah, sure. Done.
Yeah, thank you.
Do you want me to call out sound marks and olfactory marks once again, because we have already discussed it?
You can move forward to the next couple of things.
So let us move to motion marks, which is directly linked to media.
Right. Motion marks, again, objection under section 9 and regarding distinctiveness would be raised. You would have to show that it has been in use for a very long period of time. Secondly, you'll also have to show with motion marks that consumers relate to it. One way to do it is obviously you can get a survey done of consumers stamped and sealed and submit that along with the evidence at the time of filing, claiming use from whenever the mark was in use. India is a first to use system, not a first to file system, which means that you can file a trademark even though you have not been using it. From the date of use, you can claim it in the application itself. Okay, so yes, it is possible. Practical difficulty is basically this. There is no way to upload it on the online trademarks platform right now. Okay, so you can take images of it, put it together and upload it. An MP4 or a video clip is not currently allowed. So you will have to basically show different images of it.
Frame by frame.
Frame by frame, yes.
So, shall we go to color marks then?
Please.
Color marks.
Okay, color marks. Okay, with color marks, very simply this. Cadbury's, do you think color can be registered? Yes? Yes, because you relate to it, right? Okay, so the Trademarks Act says yes, color can be registered, but there's a slight tweak. It says a combination of colors can be registered. So your Colgate toothpaste, the red and white colors, Colgate red and white on a toothpaste, that can be registered. However, if you file for a single color like Cadbury's wants to do in India, it would not be in conformity with the law. So it is against the law. So even, and Pantone numbers are not ones which are taken in India, so you don't have to worry about that. It's something which is a US concept and a European Union one. It's not taken in India as of today. Okay, so you would find it difficult to get a single color registered, but a combination of colors is possible to get registered in India.
So here maybe we should elaborate on the trade dress protection also.
Yep. Yeah. So again, there's something known as trade dress, which is basically the overall look and feel of the entire product. Okay, that is a major governing factor for color. You will again have to show to the examiner why the overall scheme of the two colors relate to the consumer, and the consumer can find what the origin of that product is, okay, without that Colgate written on top of it. That is what needs to be shown and proved to get a color mark over the examination stage to registration. Okay, and there are a combination of colors, not a single color.
So one which I didn't elaborate on, that is taste marks.
Taste marks. Okay, something which is very new but very difficult to prove, exactly similar to olfactory marks. You can't save it somewhere.
Yes,
Secondly,
and the taste is so different for everyone.
For everyone, yes. Practical problems. So that is something which hasn't been filed for, and I'm not too sure if it's ever going to be filed for, because it has practical problems. Whenever you have a practical problem to be able to meet the graphical representation criteria, you're going to run afoul of it and you're not going to get it registered. Your chances of registrability come down here for such kind of situations.
So may I just take a 30-second from your presentation?
Please,
so
please.
The initial presentation where I said you imagine yourself sniffing around in the ales. Now you just imagine yourself tasting things around the ales. How weird it would be. Just have that vivid imagination in your head. Next one's a fluid marks.
Fluid marks will come under trade dress. It is possible to get it registered. Again, frame by frame, we'll have to file for it. Till the online platform allows an entire clip to be uploaded, which might happen in the not so near future, because that has been something that the stakeholders like us have asked for. It's just something that has not been incorporated into the online platform. So for now, frame by frame, you'll be able to file for it. Registration obviously depends on use, the evidence which you're showing to show that use. And when I say use, don't show 3 months of use. That's not going to work. Okay, you'll have to show elaborate use to validate that you have acquired distinctiveness through usage rather than it being inherently distinctive.
Sir, I think we have covered the
You have-
major categories.
Okay, great.
Yeah.
So this is basically how, from a practitioner standpoint, we would tackle something like this. Strategization for a non-traditional trademark has to start at the time of filing, not post-filing, not before examination, at the time of filing itself, because you know what your objection is going to be. So ask the relevant questions to your client. Post the question to them, because see, they are going to come to you and say, we want to get this or we want to get that registered. Oh, this is very famous. According to them, it is famous, but it may not be in conformity with the law. So make sure the relevant questions and the apt questions are asked by you as a practitioner to the client, because it is your job to advise them and put them onto the right path towards registration of their asset. Okay. In conclusion, this is a topic which is quite large worldwide. There are different ways to look at it, but the one way to look at it is basically this. Non-traditional trademarks are something which is going to be more and more relevant as the years go by. 15 years ago or 16 years ago when I started practicing, we didn't have this at all. It was very simple. We were just taught what a mark is. This is what a mark, words, slogans. Even slogans were considered as non-traditional at that time. Words, images, these are what you get registered. Simple, right? But over time, it has become more and more complicated, because what is now happening is with technology, with media, we're able to expand the horizon of what can be created and the manner of its creation as well. So the manner of its creation is giving us new headaches. Ma'am also talked about the headache called metaverse. Now, it's a virtual environment. Okay, we believe after a lot of debates that it is possible for us to protect our marks in the virtual environment. We don't necessarily need to actually file for this. Debate regarding filing in different classes has already been touched upon by a lot of our clients during the last 2 years. And our conclusion is basically this: the protection that we have is enough for us to stop unauthorized use, even if it is in the virtual world. Okay, unauthorized use in the virtual world, it is enough for us to stop them. We don't necessarily need to file fresh applications. If our client really wants to, because some deep pocket clients, which are mostly in the clothing industry or the shoe industry, they really want to file for their famous trademarks, That is possible to do, but you don't necessarily need to do it. Okay, so the laws that we have currently are apt to prevent unauthorized use, whether that be on a marketplace or whether that be on a virtual environment. Okay, so in conclusion, start listening to the various trademarks in and around you. Start seeing what is there on your phones, on your apps, on your OTT service providers. What you will see is the story of a lot of new technology which is creating a lot of new trademarks coming to the forefront. Our job as practitioners is to listen to those stories and to help the founders of those stories protect them. Thank you.
Thank you, Matthew. We come to the end of the discussion. Since we had a very interactive session, I'm not opening the floor for Q&A here. It's also because we are running short of time. You can, if you have any questions, you can take it up personally with the panelists. So thank you, Matthew. Thank you, Doctor. Thank you, everyone, for this, listening to this session. Thank you.
Thank you to our esteemed panelists.
Thank you for being so attentive in a post-lunch session. Thanks from both of our side for being so awake and interactive. Thank you so much.
Thank you to our esteemed panelists for sharing such diverse and thoughtful perspectives. We truly appreciate the depth of this discussion.
I now call upon Mr. Hari S. Nair, Faculty Coordinator of the Nuals Alumni Association, to present a memento as a token of appreciation to our esteemed panelists on behalf of us and our sponsors, Advocate Sairam Sanath and Advocate Paul.
With that, we come to the end of this session. Before we wrap up, I want to extend one final thank you to the batch of 2002 to 2007. Your support has been the backbone of this event, and your generosity sets a powerful example for current and future students alike. Thank you all.
will be arriving in a few minutes. I repeat, participants, please settle down.
participants kindly rise to welcome the chief guest.
Please be seated.
Ladies and gentlemen, esteemed guests, faculty members, and dear participants, good evening and welcome to the valedictory ceremony of the Nuals International Media and Entertainment Law Conclave, organized by the Nuals Alumni Association. I'd like to take this opportunity to extend our gratitude to the sponsor of our valedictory ceremony, Dandapani Associates.
The last 3 days brought together some of the most brilliant minds in the field of intellectual property, media, and entertainment law. We're truly humbled by the presence of such eminent resource persons, and we indeed look forward to have more such fruitful events that nourish the academicians within all of us. Without further ado, let us begin today's closing ceremony. I now invite Dr. Lina Akka Matthew, the Registrar of Nuals, to deliver the welcome address.
Respected dignitaries on and off the dais, members of the faculty, staff, alumni, and dear participants. We are at the end of the third day on the legal conclave on media and entertainment law, organized by the Nuals Alumni Association. And we are very happy that our Alumni Association has taken such an active interest in updating the knowledge base of our students on media laws by bringing in legal experts into our campus. We are also very proud that the faculty coordinators, Sri Hari S. Nair and Dr. Nandita Narayan, along with their able team of student volunteers, have put in their unstinting efforts to ensure the success of this program. It is my duty to welcome the esteemed guests to this valedictory session. I welcome Honorable Mr. Justice S. Sirijagan, Acting Vice Chancellor, who will be delivering the presidential address. The Honorable Minister for Higher Education and Social Justice, Dr. R. Bindu, is our chief guest to grace this session. Madam will be delivering the valedictory address. I welcome the Honorable Minister, Dr. R. Bindu, on behalf of Nuals. Dr. Nandita Narayan, Convener, ICMEL, and Assistant Professor Nuals, will be delivering the vote of thanks. I welcome Dr. Nandita on this occasion, on behalf of Nuals. I welcome all participants, faculty members, staff, alumni, and resource persons to this valedictory session. Thank you.
Thank you, ma'am, for your warm welcome. Now I request our esteemed Vice Chancellor, Dr. Sirijagan, to deliver the presidential address.
today's chief guest, Honorable Minister for Higher Education, Madam R. Bindu, Registrar Srimati Leena Akka Matthew, Srimati Nandita Narayan, members of the faculty, alumni, resource persons, and my dear friends. I first congratulate the Alumni Association for having taken the pains to have such an international conclave in this university. However, I am a little disappointed with the participation of the alumni members. Whenever the Alumni Association conducts some program here, there is no constant attendance. Only one face comes to my mind when I speak about Alumni Association, that is that of Muttumani. That is the only face I remember. Even the former office bearers, they are also absent here. I would tell you that now, after the advent of the accreditation, NAC accreditation, the Alumni Association is a very essential part for the betterment of this university. Therefore, I would suggest that the Alumni Association may take some more interest in having such seminars or conclaves in the university, so that when the inspection team for NAC accreditation comes, we will have something to show them to prove the participation of the Alumni Association of this university. When I am an alumni member of the SN College, Kollam. When the inspection team came for NAC accreditation inspection of SN College, Kollam, the then principal invited me to be present there to have interaction with the inspection team. I myself and another alumni, Mr. Justice Sridharan, was also present there. And the inspection team had a very long discussion with us on that day. Therefore, the Alumni Association is a very important factor in the matter of NAC accreditation, which the Alumni Association may take into account with regard to your future activities in this university. I am very happy and that we are fortunate enough to have the Honorable Minister, Madam R. Bindu, for the valedictory function today. She takes very keen interest in the progress of this university, and we are thankful for all what the Honorable Minister has done for this university. The subject of this conclave is media and entertainment laws. I'm not sure whether there is any law as such for media and entertainment in our country. The reputation of the media, both regular media and social media is not very promising in our country. In fact, I read in the newspapers that the foreign nations have very poor opinion about the media in our country. I also have very bad experience with the media when I was a judge. The reporting of judgments of the courts is not very encouraging of our media. Very recently, when the High Court of Kerala rejected an anticipatory bail petition, the accused went to the Supreme Court and obtained an order. The media published it as an interim protection from arrest. I was very surprised because the Supreme Court themselves had specifically laid down that the high courts or the lower courts shall not grant interim protection from arrest. I was wondering why Supreme Court then did this. Thereafter, I could see the bail order itself. From that, I understood that it was not an interim protection from arrest order at all. It was an interim anticipatory bail itself. In fact, today, a division bench of the Kerala High Court has warned the media about news items regarding matters relating to Hema Committee report. The media generally are more interested in truth than more interested in their TRP ratings than truth. This sad state of affairs should change. I hope that the 3 days conclave has come up with very important suggestions regarding how our media and entertainment laws should change for the betterment of our society. With these few words, I leave the stage for Madam Bindu, the Honorable Minister, and let us hear our Minister. Thank you. Jai Hind.
We express our sincere gratitude for those insightful reflections, sir. Now, it is my great honor to introduce our chief guest for the valedictory function, Dr. R. Bindu, the Honorable Minister for Higher Education and Social Justice, Kerala, and the Pro-Chancellor of Nuals. She was a member of the Advisory Board of the first Kerala State Higher Education Council and has also served as a State Resource Member of the National Literacy Mission. We are privileged to have such a distinguished leader in education with us today. Dr. Bindu, we invite you to deliver the valedictory address.
Respected Vice Chancellor, Honorable Justice Shri S. Siri Jagan, Dr. Lini Akka Matthew, Dr. Nandita Narayan, participants and scholars, faculty, students, and my dear friends. At the very outset, on behalf of the Department of Higher Education, Government of Kerala, let me extend warm greetings to all of you. I have immense pleasure to place on record my appreciation for the organizers, Nuals Alumni Association, and the participants of this highly relevant conclave, which caught by its horns one of the most vexing conundrums of the contemporary world, namely the complicated relationship between law and the media. The vitally robust nature of media depend on freedom of expression and speech, whereas law envisages restriction, regulation, and interdiction. The very fact that media have to assert freedom and liberty as inherent values entails as its natural corollary the necessity of having to resort to law as its check and balance, without which the freedom might become meaningless. Thus, this is an essential marriage of an unlikely pair. The law being an enforcer and constraint on liberty at the same time, it becomes a mandatory ally for the media, and hence this conclave is a step in the right and proper direction. Even though I am not a legal expert, being a person who has been active in the public sphere as a social worker for the last 40 years, I would like to present some of my observations in this regard. French social philosopher Louis Althusser considers both media and law as part of the ideological state apparatus, a concept he uses to refer to institutions and systems that help to reproduce and legitimize the existing power structure and the hegemony of the dominant and powerful sections of society. In the present neoliberal, globalized, advanced capitalist situation, we see the increasing power of the corporates and both the legal systems and the media as part of the ideological state apparatus become more and more involved in securing consent and legitimacy for the operations of corporate power in various societies. As far as media is concerned, we see the fast pace at which the conglomerate tendencies in the field escalate. Media conglomerate, or one company owning many media outlets, grows to become media baron or media tycoon, and they establish themselves as kingmakers. They actively participate in the process of carving out formulae related to power and become omnipotent in all senses of the term. We see escalation of amalgamation, process of amalgamation in media industry also. This conclave is especially significant at this present time, when the role of the media and its many transgressions have been constantly hotly debated. Most of the time, we make the mistake of focusing on the message, the content that media apparently carries. Though media theorists like Marshall McLuhan would tell you that the medium is the message. Even without any purported content, the medium on its own communicates. McLuhan's famous example was that of the light bulb, which, without any apparent content, has transformed our spaces and redefined them by making them accessible during darkness. The light bulb has contributed more to the constitution of modern space by lighting up and reclaiming space from darkness more than what the newspapers or television has done. This is not to forget that before the advent of the smartphone, television had already wreaked havoc in our household spaces by smothering communication and turning individuals to mere spectators, mute spectators. Individuals have been reduced to miserable victims of the commercial interests of the profit-seeking, market-oriented ethos of commercial capitalism, and media play a pivotal role in preparing the social and political atmosphere congenial to the market forces. Look at what the so-called social media has done to modern communication. It's an example that was not available to McLuhan, but is clearly predicted by his theory. Contemporary social media have redefined the classical communication model, which is a reversible process involving a sender, a message, and a receiver. By effectively masking the sender, who is now comfortably couched in the protective anonymity of the medium, and by exploding the receiver into 1,000 faceless non-entities, the social media have collapsed communication into the medium. It smacks of a public space with all the invisibility offered by a private space that has turned it into a slough of psychological dirt, where a desperate humanity discovers its own baseness and evil. Rather than the thief and the murderer, whose subjective authenticity makes their act cognizable, the acts of the social media communicator are prompted by what Roland Barthes would call the death of the author. Modern social media have made every individual into a publishable author, a fact that could not happen in the print media era, but an author who has committed suicide in a desperate attempt to discover their own identity. Freud would have been exceedingly happy to analyze the demotic language they slip into, the sordid self-actualization they achieve. Law is mostly baffled by these schools of scandal, where at every word a character dies. Shielded by mechanical devices, this murderous humanity goes on its rampage, unimpeded by the checks and restraints even the most advanced jurisprudence manages to put forth. At the same time, social media can be a powerful tool in exposing the clandestine operations happen within the corridors of power. They can be effectively utilized in resisting injustices and inequalities associated with the power hierarchy. Laws are to be formed to safeguard the positive dimensions of the social media and to check the negative aspects. That Janus face social media is to be handled with care. This brings us to another, a still more dangerous aspect of modern communication, which a theorist like Noam Chomsky called its ability to manufacture consent. Edward S. Herman and Noam Chomsky, in their seminal work, Manufacturing Consent, The Political Economy of the Mass Media, argues that the media in the United States are effective and powerful ideological institutions that carry out a system supportive of propaganda function by reliance on market forces, internalized assumptions, and self-censorship, and without even overt coercion. What they say about media in the US are true about media everywhere in the modern world. Media are usually financed either through advertising, which subordinates it to commercial interests of large corporations, or through subscription, which submits it to the vagaries of middle-class aspirations. The media works to bring the larger masses into an unconscious agreement, a covert covenant they have entered without their knowledge or intention, that reflects the desires of the powers that control the media. Instead of dispassionately reporting truth, as our Vice Chancellor has stated, media participates in the manufacturing of the truth it reports. That is fake. In the 1960s itself, the Western media started intervening into elections through a function they called agenda setting. They tried to influence popular franchise by bringing into focus the points for debate they thought important, or their financiers thought important for themselves. Now, with the advent of internet-based modern social media, this function has made inroads into the social space at large in all its ideological glory. That brings me to the last point I want to talk about today, the fact that I think the justice system is caught in the quagmire of social media offenses. Apart from the fact that financial offenses as well as attacks on personal life have escalated and bringing the offenders to book, offenders being booked, has never been this difficult. The protean nature of cybercrime makes it a challenge to any justice system to efficiently tackle. Augmenting this complication is the advent of artificial intelligence and its impact on life in general. From John McCarthy's 1956 summer research project on artificial intelligence, the new technology has come a long way to encompass and subsume all walks of human life, including law. Its use in converting trial transcripts into digital format, in processing information provided by a client to predict the likely outcome of the case, for the analysis of statutory legislation, and in processing evidentiary material has been explored since the 1960s. Artificial intelligence applications are known to assist in solving legal questions and in assisting legal reasoning by searching millions of pages of legal text in a matter of minutes and coming up with manageable summaries focusing on relevant information. But artificial intelligence is no longer a mere tool. It is emerging into an agent that does not act on behalf of any human agent, but on behalf of itself. This will create new problems for the legal system because such a future will make it difficult to fix individual responsibility. Artificial intelligence produced intellectual property will also augur the need for new regulation regarding intellectual property rights. Artificial intelligence will also make freedom of speech a highly problematic area. Can expression of an AI tool be ascribed with intention and thus brought to justice? If somebody claims an artificial intelligence produced text as his or her own, how will the justice system, the judicial system, decide on ownership unequivocally? The questions and problems increase as we explore new media and modes of communication that do not automatically follow human rules. In addition, what will happen if the human jurors are replaced with artificial intelligence jurors, a simple app that can, in a matter of minutes, pore over millions of legal documents and arrive at an objective judgment? Can the world afford to be so non-human? Before I conclude, let me express some anxieties which spring up from the present Indian situation. The proposed amendments to the IT Rules 2021 and the subsequent bans and censorships obviously demand close scrutiny of the possibilities of curtailment of freedom of thought and expression. The arrest of journalists like Prabir Purkayastha and Amit Chakravarti and some others under UAPA raised controversies. India's ranking on the World Press Freedom Index has consistently fallen in the last decade, dropping to 161 out of 180 countries in 2023. The government has also proposed a fact-checking unit to monitor social media, sparking concerns about censorship. On this note of a foreboding, let me conclude by congratulating the university and Alumni Association, the organizers of this conclave, on their daring attempt to address one of the most relevant areas of judicial system at the present time. Thank you.
Thank you, ma'am. We are truly grateful for those inspiring words that perfectly encapsulate the spirit of our conclave. Now, we invite our esteemed chief guest, Honorable Dr. R. Bindu, for the prize distribution ceremony.
The first category, top 5 papers, and this is in no particular order. IC 90, Matrika Shukla, explicit content on OTT platforms, a social-legal analysis amidst emerging regulations. IC 132, Sita Lakshmi and Atulya MP, Indian music industry and copyright law, issues and challenges, and a study of the relationship between the music industry and copyright law. IC 1, IC1, Devinath A, Kashmira Nashir, reminiscing possible developments of blockchain and smart contracts in copyright and music industry. IC12, Garima P. Baisare, comparative analysis of media and entertainment laws across different jurisdictions and the effect of international streaming on municipal laws. And IC44, Venugopal P, sensationalized news coverage in India and emerging contours of law.
The award for the best presentation goes to IC10 for the paper titled Digital Streaming's Role in Copyright Protection and Musician Earnings, written by Neeta Mary Matthew and A. Madhuvanti.
Finally, the award for the best paper goes to the paper titled Transparency, Accountability and the Quest for Fair Royalty Distribution by Copyright Societies in India, a qualitative analysis of judicial precedents from 2012 to 2024, authored by Sonisha Srinivasan, Surabhi R. Kanadam and Dr. Abhishek Chakrabarti. Congratulations to the team. I would now like to call upon a few participants of this conclave to share their experience and their thoughts on this 3-day conclave. If any one of you would like to share your thoughts, please do raise your hands and a mic will reach you.
Namaste everyone, this is Ravi Vyas from Gujarat. As they just said, in sloka number 54 of chapter number 2 of Srimad Bhagavad Gita, and that is Sthita Pragnasya Kabhasa Tusyante Ramante Tatra Devata, means if the person can thought beyond his comfort, he can be a good human being. And if you see the title of our conference is the Media and Entertainment Law along with the uniqueness, and that is the IPRS. So since 3 days, I observed a lot of things, and positively and proudly I am saying that I am standing in the land of Professor Madhva Menon sir, another Justice Krishna Iyer sir, and third Chief Justice of Kerala UL Bhatt sir. Actually they pushed me to take admission in the law field, and I feel proud to stand in the particular land of that particular thing. As far as the conference concerned, since 3 days, I learned a lot of things from media to entertainment law, along with the particularly focus on the copyright law. Many sections are there. Geneva Conventions are there. Rome Convention is there. Bern Convention is there. Along with the judgments particularly given by the Justice Krishna here, as Dr. Raghavendra sir says, along with the metaverse subject. Another point is the fire chat, which is done by Sandeep sir from our university. Actually, it is really a best presentation that I ever seen in my life. Another point is that actually every student have a dream to be a part of NLUs. Actually, I am the one in my line past that one day I went one university, but they don't allow me to enter in the NLU. At that point, I thought that one day I be there and give a presentations to a particular that university. And today, that particular thing and dream came true, that I gave a presentation in some universities. And another point, sir, is there. One point is that in Kerala state there is a 100% literacy rate. But another point is that if you focus on the sustainable development goals, we see that it is targeted by 2030. But if you see the rate that Kerala is the first state actually who have totally focused on the sustainable development goals. And these kind of things gives a message that really the particular state deserves these kind of things. And thank you again to give me the opportunity. Last but not least, I want to quote one sloka of Srimad Bhagavad Gita, sloka number 700, chapter number 18, Yatra Yogeshwara Krishna, Yatra Partho Dhanurdhara, Tatra Si Vijayo Bhuti, Dovanitir Matin Mama. At the end, implementation matters. And last but not least, I want to thank particularly Nandita ma'am, Hari sir, and all the volunteers who are working sleeplessly since 4 days. I know the name Ritvika, Vinay Bhai, and I forget the names, but and someone also have problems in leg, in body. I observed a lot of, I forget that guy actually. Where is that guy? I really feeling positively for him because he have a problem in leg till when I want work, I want help, he fearlessly helped me at that moment. So thank you very much again. Thank you very much.
Is there anyone else? All right.
Thank you for that heartwarming feedback, sir. We truly appreciate it. I now request Honorable Justice S. Siri Jagan, Acting Vice Chancellor of Nuals, to hand over the memento to our Chief Guest as a token of our gratitude and appreciation.
Thank you, sir. I would like to take a moment of your time to give a very special shout out for TEDx Nuals 2024 Musics in Twilight, which is happening on the 19th of October 2024. I would like to call upon the President, Nuals Student Council, and the convener, TEDx Nuals 2024, Gokul Kesanoj, to speak a few words on the event.
Respected Chief Guest, respected Vice Chancellor, respected Registrar of the University, Nandita ma'am, professors, faculty members, guests, and dear friends. I will not take too much of your time. I'm aware that you are all exhausted after the grilling academic event that happened for the past 3 days. But 2 weeks from now, exactly at this very venue, we are set to have a whole new universe open up. Our university will be hosting the first edition of TEDx Nuals, the largest ever event of this kind in Kerala so far, and in any law university for that matter, with a lineup of over 13 speakers visiting our campus. walking, talking, and sharing stories with us. Walking, talking, and sharing stories with us will be Navteej Singh Johar, the petitioner from the landmark judgment that's bread and butter to our profession today. Our Member of Parliament, Mr. Haibi Eden sir, who holds a world record for the largest number of menstrual cup conversions ever. Dr. Vasuki IAS, Kerala Government's External Secretary, External Cooperation Secretary, and the director and filmmaker, Geo Baby sir, who directed the movie Kadal the Core starring Mammootty, and The Great Indian Kitchen starring Nimisha Sajan. We have 9 more exciting speakers lined up who are movers of mountains and shakers of the world, who I assure you will not just leave you all inspired, but will also sit close to you, have small chats with you, and move your lives and connect with you. See you in 2 weeks. Thank you. Reach out to us for any queries, tedxnuals.com. Thank you.
Once again, before this evening comes to an end, I would like to ask, is there any other participant who would like to share their thoughts on the last 3 days?
Hello. Hi everyone, I'm Sandra Sunil, PG student at GNLU Gujarat. First of all, let me say I came here because it was a mandatory criteria for my PG program. But I would say it was actually worth coming. First of all, almost I believe 100 plus students could participate and present their paper. Together with that, I feel like the most number of sessions that could be conducted in 3 days to cover this topic entirely has been conducted. Not just by academicians, but we were able to get different point of views from experts like practicing lawyers, corporate lawyers, plus academicians, which I believe was one of the milestones that this conference could give us. Together with that, I would say that of the conference I have attended, I feel like this was the one which managed the time pretty well, that a number of sessions were arranged from the morning till afternoon, for which I give the complete credit to the OC members who worked day and night to arrange it in such a way that everything that has been scheduled has been conducted in a very wonderful way, even though slight delays, which I believe all the participants could of course understand. And the organization, everything was, I believe, perfect to the point. Thank you so much for this opportunity, not just for giving me and everyone the opportunity to present their paper, but also to give possibly I could say an entire course on media and entertainment law together with intellectual property rights. Thank you so much.
Thank you for those heartfelt words. As we come to the close of our ceremony, I now invite Dr. Nandita Narayan, convener and assistant professor at Nuals, to deliver the vote of thanks.
Good evening, everyone. I take up this role of rendering the vote of thanks with great pleasure. I would first like to place on record the Nuals Alumni Association is truly humbled by the presence of our chief guest of the day, Honorable Minister R. Bindu. Thank you, Madam, for taking the time out of your busy schedule and joining us here. The International Media and Entertainment Conclave was a brainchild of the Alumni Association. We have been toiling day in and day out for the past 1 year, especially intensely for the past 2 months. Our alumni is spread all across the globe, from US to UK, from Singapore to Dubai. So it is actually impossible for them to be physically present when the event is happening. But this event was live streamed. They all joined us online. And to make their presence felt, they have considerably and wholeheartedly contributed to this event. We have had amazing contributions come in, especially from all the batches, especially the first 5 batches. So it's a shout out to all of our alumni for supporting us virtually and in their hearts and souls. This was seen as an opportunity by many to give back to the alma mater, and they are very intensely and very emotionally associated with this university. And this is just the first leg of the event. We would like to take it forward, hopefully, fingers crossed, in the coming years. And this is purely an alumni association initiative. Having said that, I would like to thank our Honorable Vice Chancellor, Justice Siri Jagan sir. The minute we approached him, he wholeheartedly supported this cause. He has taken away all the hassles and shackles that have come across our way. So thank you, sir, for your support. I would also like to thank our registrar, our administration head, Lina ma'am. She has been a pillar of support and has answered all our queries and has supported us at every beck and call. Thank you, ma'am, for all your support. I know the last 3 days have been very eventful. We have had a very hectic schedule. We have had around 25 resource persons who have traveled from different parts of the country just to be here in the given 3 days. We have had 6 international resource persons join us online at different timelines. So there are resource persons who have joined us as early as 6 a.m. in their time zone and as late as 1 a.m. again in their time zone. So it has been very eventful, and from the bottom of the organizing committee and Nuals Alumni Association, I thank all the participants for having sat through this hectic schedule and having contributed in your own ways. So thank you to all the participants. Again, I would wholeheartedly like to place on record our gratitude to all the sponsors, whether it be alumni or whether it be organizations such as Muthoot Finance, we have Dandabani Associates. All of them, all these sponsors have contributed to this cause. So I place on record our gratitude to all our sponsors. And then I cannot conclude without being immensely grateful to all our student volunteers. They have literally spent sleepless nights, and this is literally, it is not a metaphor. They have literally spent sleepless nights. Like Ravi Vyas was pointing out, many of them fell ill in between. But this is a huge shout out and a huge, thank you from the Alumni Association for being with us and for making this event possible. So I would like to thank the food committee, the travel and accommodation committee, the reception and POCs, the stage committee, the registration committee, and I'm so sorry if I missed out anything, but thank you guys, thank you for supporting us. And finally, to mark the end of this event, I would like to thank all the alumni who have been here physically and who has been present here and supporting us in all in 3 of these days. Again, our beloved faculty, I don't think we need to thank them. Whatever we do, they are here with us. My colleagues, my teachers, thank you everyone for all your support, administrative staff, everybody. So thank you, good night, have a great day.
Thank you, Dr. Narayan, for those words of gratitude and for your tireless efforts in organizing this conclave. With this, we come to the end of the 3-day International Conclave on Media and Entertainment Law 2024, sponsored by Trilegal. Thank you to all the participants for their presence and contributions. We hope you found the conclave enriching and that you'll carry forward the insights gained here. Thank you once again and have a great evening ahead. Requesting all the participants to rise for the national anthem. Participants, please note that the bus will fly from the campus at 7:15. I repeat, please note that the bus will fly at 7:15 p.m. Thank you.
And all participants are requested to stay back to collect their participation.